thank Laura Cahalane and Donal Coffey for organising this wonderful conference and bringing us all together, academics, the Attorney General, journalists, commentators and thinkers. My name is Aileen Kavanagh. I'm at Trinity College Dublin, but I spent many years in England, at the University of Oxford, and one, if you like, perspective from outside was that the constitutional achievements within Ireland are sometimes overlooked outside of Ireland. But when it comes to the 1922 Constitution, I think I would echo Laura Cahalane's comment at the very beginning that actually the 1922 Constitution, its achievement is sometimes overlooked within Ireland as well. With 100 years of stable constitutional democracy in this country, we join together with very few countries around the world that can lay such a claim of democratic longevity and resilience over time. I'm absolutely delighted to chair this particular panel about the role of the people in the 1922 Constitution. This, for me, as a constitutional lawyer, is the golden thread, the principle of popular sovereignty, which was carried through then to the 1937 Constitution and became a form of democratic innovation, which was unique for its time in 1922 and still highly innovative in 1937. And when we look around the world today at populist regimes and a degeneration of democracy, we can only marvel at what came very shortly after a civil war in Ireland and a constitutional compact that then held. So you've got a wonderful panel here. William Quill, a barrister specialising in administrative law, Dr. Alan Greene, who joins us from the University of Birmingham, Dr. Tom Hickey from DCU, and Dr. Jennifer Kavanagh from the Southeastern Technical University. With no more ado, I will hand over to William Quill, who's going to talk about amending the 1922 Constitution and the path towards our current Constitution, Bunreacht na hÉireann. William.
Thank you. Thank you, and thank you again, of course, to Donal and Laura. And my comments here today, in some ways, they add depth to, or excuse me, no ways could I think to add depth, but add certain detail to comments you heard from the attorney and on how it was the Constitution itself was amended. And a large part of the story of the Irish, the history of the 22 Constitution was that it was full of amendments. In its 15 years in operation, there were 25 amendments. And this contrasts with our current Constitution, which has been in operation for 85 years and has been amended 32 times, most of those actually in the later part in the more recent years. What I want to look at here today is, first of all, I want to bring you through the amendment procedure, both what was the explicit amendments, how that was amended, and what that also led to there, which we again heard from the attorney this morning, in what happened about the question of implicit amendments and how the Constitution could be amended without a bill proposed to amend the Constitution. I want to discuss a little bit what these amendments actually were. Some of these, the other panelists later today will go into more discussion of them, so I just want to give this in some ways be outline to that. But also look at how, despite the flaws in this, it still laid a groundwork for what I think is a very solid amendment procedure we have in the 37 Constitution. So to consider first the amendment procedure. And I just want to just outline here that we had the Constitution itself was approved by the Third Dáil, and the election to that Third Dáil took place in June 22. So after we heard earlier the drafts of the Constitution were considered in May, approved by the provisional government, eventually we see a draft proposed on the day the Third Dáil is elected. And the primary purpose of that Third Dáil before the 6th of December is really to approve that Constitution, adopted by, before it had full legislative authority, Dáil Éireann sitting as a Constituent Assembly in a provisional Parliament. But for looking forward for any Constitution, needs not just to be adopted in that current moment, whether it be 6th of December, 22 or December 37, but something to have that continued legitimacy needs to be provisions for it to be amended and amended, there to be support for the amendment. So to consider amendments, those drafting constitutions consider either the two approaches, in some ways either political consensus, achieving political consensus for an amendment, or popular consensus. And the drafters of the Constitution compiled what's actually quite interesting, a full booklet of constitutions that were in operation at the time. And lots of parts of throughout the whole text of the Constitution, you can see borrowings from one constitution, another constitution. And the amendment procedure itself was no different to that. So there are two approaches there. In terms of the political consensus, we see that the Weimar Constitution, the German Constitution, would just come into operation, where the emphasis in that case was on finding 2/3 of the Parliament, both houses of the Parliament. And there was a provision, I won't go into this here, but there was provision for referendums on amendments, but essentially an amendment initiated politically was to be approved by 2/3 of those in both houses. The other approach would be that of the Australian Constitution. And in that case, was based on popular consensus, that an amendment proposed through both houses would have to pass by a popular referendum. A side note on this is that it also had to be approved by the majority of the states. It's there, but fundamentally that it's the popular vote that has been proved the difficulty for most of the constitutional amendments in Australia. So what did we choose in 22 was that amendments would be, the draft initially proposed to the Dáil was that this would be by votes of the people, with provisions on ensuring sufficient numbers of voters, a sufficient turnout figure. What was then considered when this was proposed is that, for all the reasons we heard earlier on, that without the long time to develop the text, it was recognised that there should be a period for housekeeping amendments. And this was proposed by Kavanagh Higgins for the government, what will be coming well. But actually this was approved of by the opposition. Thomas Johnson, Labour leader, who was the opposition at the time, didn't see anything subversive in allowing amendments by the Oireachtas alone, and actually proposed this to be extended to 8 years, which would be, as it was then, 2 full Dáil terms. And so you can see there that as enacted here, this be by 8 years. What is crucial, and what was again referred to by the attorney, is that for a period of 8 years, amendments to the Constitution could take place by ordinary legislation, without reference to a referendum. What this ultimately allowed to happen was that the government used that provision to amend that itself, so that the 8 years by ordinary legislation became 16 years. And we see that by the time, and as well as some other amendments here, by the time at the end of it, for 16 years, and in fact, as it was in operation only for 15 years, for the entire period of its operation, it could be amended without reference to referendum. What we, I'll leave that aside to come back to that in questions. What the effect of this 8 years provision had two things. One is to say that throughout the whole period it was never put to referendum. And this meant that, even considering its Irish term, a bon racht, or a fundamental law of what a constitution is, it never reached that status there, never reached that sense of being different from other legislation. It provided that structure that we needed there, whether it be there was Article 11 on the environment, or whether it be the structure of the government. It provided that, but it didn't become different to other legislation, and not just because it could be amended simply by means, because as again was referred to this morning, it could be amended by indirect amendment, implicit amendment. Quite early then, it was viewed that an amendment, that legislation that contradicted the Constitution could not be impugned, because an amendment is something it was considered to impliedly amend it on adopting only ordinary statutes of interpretation of law following a previous one is considered to be superior to one that took place earlier. And something that even today, actually, interestingly, the British law does see some laws as more constitutional that have to be explicitly amended. And then this was referred to in statutes itself began to adopt. It was only adopted once, but the idea that any provision in this Act contrary to the amendment contrary to the Constitution should be considered to be an amendment of the Constitution. So to move briefly through the amendments in practice, I just want to, as an outline here, one of the innovations of the 22 Constitution, and something that we'll hear from Dr. Kenny this afternoon, was the ways in which it diverged from the Westminster model. And in some ways, we think, because of the nature of the Civil War, we think of the imitations in form. We think of, oh, there was the Oath of Allegiance. We had a Governor-General. But there are many ways in which it differed. We had the fact of a referendum was possible. The fact there was the idea of the initiative. This was that people could petition the Dáil, petition the Oireachtas to discuss a particular matter. We had certain constitutional matters that were different. The fact of it having a constitution itself was a divergence from the Westminster model. The nature of judicial review, that the judges could come in and look at that, and our electoral system. And what we see over the course of between 22 and 37, that these differences in substance, apart from PRS-TV remaining, in one way or another, either completely or in effect on their substance and meaning. So completely in terms of referendums and the initiative, and then in how they were intended, perhaps, on questions such as the power of the Constitution over other laws, were bit by bit removed through amendments from the first period of government of 22 to 32 under Kavanagh. Then we see under that second period of 32 to 37 that the De Valera government slowly moves, bit by bit, moves those parts that seem imitations in form, such as the oath. Before Fianna Fáil had and De Valera's group party there, that whether previously still part of Sinn Féin, had stayed out of the Dáil until 1927. And during that period, there was consensus around the operation of the Constitution, and there was an all-party committee formed on amendment to the Constitution. And you can see that the amendments they were considering were, as I referred to, those housekeeping amendments. And they weren't particularly contentious, those how long the Dáil should be, the ways of re-election the Ceann Comhairle. What we see there is that after 27, that the Constitution begins to become a contentious matter. And this is when any efforts to achieve political consensus leave aside the question of popular consensus. Is dissipated. So De Valera wished to use the initiative measure to attack the oath, and immediately in response to that, the Kavanagh government moved to remove those articles 47 and 48, which in different ways allowed petitions and referendums on matters other than the Constitution itself, and then become on essentially a government opposition vote. So you can see this series, as we move forward here, we see more and more divisions. The numbers there relate to divisions within the Dáil on this, whereas previously fairly uncontentious matters. There are one or two uncontentious there. And you can see there that the opposition also, in a case where some things are just purely on party line, has no incentive to act constructively. So De Valera, as you can see there, he's voted to make things worse, to make things better. And by simply being obstructive, we see opposition politics forming on the Constitution. And I suppose the two most significant amendments that get the most attention are Amendment number 16, which extended the period in which amendments could be made to the 16 years, and then which wasn't politically contentious because Fianna Fáil and De Valera anticipated they could use these provisions themselves in turn. But it did help to undermine the effect of the Constitution. And Amendment number 17, inserting Article 2A, which allowed quite extensive military tribunals. So it undermined really that sense of the rule of law, that protection to the Constitution there, and something that notably has actually continued to be referred to and considered to be judicially considered there. It was considered earlier this year in the consideration of the Special Criminal Court, and Mr. Justice Gerard Hogan considered how it was quite much looser than any form of special criminal court we see today. I think we'll have discussions there later there in this panel on that. And so generally speaking, the Fianna Fáil amendments were again mostly quite politically charged, divisive. As soon as De Valera moved in, he moved to remove the oath, which finally passed after a second general election, quite early in less than a year after he had entered office. And then as we move on, questions such as the abolition of the Seanad, the abolition of the Governor-General, becoming politically contentious, and that by the very end, on the significant date in the British monarchy of the 11th of December, the abdication of Edward VIII, by this time the Seanad itself had been abolished, and then there's in one day, legislation could be initiated, passed through all committee stages, and as soon as the Ceann Comhairle signed it off, became law, an amendment to the Constitution could be made in those hastened circumstances. So we see, overall there, before I move to the question of its impact on 37, and there's still a legacy to that procedure, and even the question of allowing amendment there, that neither form of political consensus was achieved. The popular consensus model of amending a constitution, which was in the text of the Constitution, wasn't achieved because none of these referendums were put to the people. None of these amendments were put to the people. And neither was political consensus achieved, that apart from what we call the housekeeping or minor amendments, that so many of these came down to some cases quite close votes, and in any case what were seen generally as the government are supporting the government versus opposition, and generally supporting the lead opposition there. Now, having said that, I think through all of this, there was an influence on the 37 Constitution, both as drafted and even this provision on allowing amendments by the legislature. One is, just without going into the detail here, there are two provisions in amending the 37 Constitution. The one which we're all familiar with, at least in terms of how its effect on us as citizens, that the amendments that we vote on in any referendum, that they pass through, first all initiated by the Dáil, must then pass through both houses, then put to a referendum. But there was also that provision for a short period of allowing amendments through ordinary means, without reference to a referendum. And the lesson from 22 in that, the first was that what Kavanagh Higgins had proposed in that committee stage, and what Thomas Johnson, then leader of the opposition, had supported, was actually a good idea. It is true that if you have a large text there, and then if you realise that how one house relates to another, or the timing of legislation should be altered in some small way, it is good that there are means that, in short experience, that you should be able to amend it without reference to that necessarily having to hold a referendum over small matters within a very short period. We also see there that it is one is affected the other. So the fact of the 22 Constitution being dissipated through becoming ordinary politics meant that it strengthened the reason for the 37 being put to the people. This to be different from what happened in 22 and in the amendments after that, that there was a greater impetus for the 37 Constitution would have a greater authority by being approved by the people. So we had 22 Constitution, which was approved by that third Dáil and only ever amended by the Oireachtas, and the 37 Constitution adopted by plebiscite with two exceptions, which I will touch on there, amended by after a referendum. And then just to consider what was different with this small provision there that allowed a 3-year period. And this Article 51 allowed a 3-year period where amendments could be made by bills passing through the Oireachtas. And it was limited to a 3-year period, which is shorter than the Dáil term rather than longer than one. And it was an operation only from the start of the first president's term in office. So, for example, it would mean that with a similar procedure to the reference of bills to the Supreme Court. So therefore, there was that protection there of the president as protecting of the people's interests. And so that it was only once the president came into office that was there as a protection there. And finally, and possibly most crucially and distinctly there, it explicitly ruled out amendment of that same provision itself, or Article 46, so that it was a very strictly limited period. And there were two amendments, one of which on the outbreak of the First World War, and the second of which was a general amendment, some of more substance than others, which a series of amendments, 40 in total, were made to the text to allow that period there of consideration. So I'll conclude there, and just in general there, that the lessons of that amendment procedure, I haven't gone into the substance there because I realised that both there's a lot to cover in that, and also that a lot comes up in the discussions later in this panel and through that today. Thank you.
Well, many thanks, William. A very rich presentation, and we'll go over now to continue this theme of people, the role of the people in the 1922 Constitution, with Dr. Alan Greene, who's going to talk about constituent power and the Irish constitutional imagination.
Thank you. I have slides, but they're just for me. So I'm going to talk about constituent power and Irish conceptions of what constituent power is, or really Irish, arguably, ambivalence towards what actually constituent power is, or at least the language of constituent power. So very often we seem to, and particularly when we look at the judgments of Ryan versus Lennon, and particularly the judgment of the Chief Justice, there is sort of a hint at a conception of constituent power there, but without actually unpacking kind of what that is, or actually expressly using the term constituent power. And my key issue is, does it matter? So, firstly, what is constituent power? So, at the simplest form, constituent power is the power to create a constitution. And the conception of it was the tracing of it is traced back to Emmanuel Sieyès, who's one of the leading legal theorists of the French Revolution, and was trying to come up with essentially a justification for the convening of the Estates General, and why the Third Estate in particular was able to assume the primary constitutional drafting powers, and essentially looking for a justification to overthrow the ancient regime. And so Sieyès constructs this idea of constituent power, as describes it as the moment, it's exercised at the moment of a constitution's founding, and it expresses the essential relation between the people and the state. And he vests constituent power in the Third Estate, which was essentially the commons, for want of a better word. So he's essentially saying that the nation possesses constituent power. And we've kind of evolved that into the idea of the people possessing constituent power. And the exercise of constituent power creates the Constitution. And then we have a distinction between the constituent power and the constituted powers, the legislature, the executive, and the judiciary. And their existence essentially derives from that original exercise of constituent power. So that distinction between constituent power and the subsequent constituted powers is quite important. What's also important, and is what quite unclear in constituent power theory, is the relation between the actual constituent power and the constitutional order that has been created. So constituent power has this almost constructive and destructive potential. So it's constructive in the sense that we're exercising it to create a brand new constitution. But it's also destructive in the sense that its exercise destroys the order that came before it. So particularly in the French Revolution, its exercise destroyed the ancient regime that existed. So as a result of that, constituent power is often conceptualized at the moment of revolution. So that is when it is exercised. But it raises the question as to what is its relation to the subsequent constitutional order that has been established. So we have two different conceptions. We have closed models of constituent power and open models. Closed models are those that essentially try to argue that once constituent power is exercised, we have no need for it anymore. The Constitution runs, all state power is exercised through the constituted powers. And you can even conceptualize the constitutional amendment power itself as a constituted power. Open models of constituent power argue the opposite, and they say that yes, constituent power is exercised at the moment of constitutional creation, but in order for, say, reasons of democratic legitimacy, it needs to be able to exercise again. And there are some who maybe argue that actually the amendment power is an expression of constituent power. So there's certainly ambivalence as to whether the constitutional amendment power is an exercise in constituent power or is it a constituted power. But bearing in mind, because of this tense relationship that the exercise of constituent power has with the actual constitution that has been created, there is very often a skepticism of constituent power because of that destructive potential, notwithstanding its potential democratic legitimacy that it can insert. So as I've suggested, therefore, the possessor of constituent power, who possesses constituent power, ideally it should be possessed by the people. But that raises the question as to how does the people actually exercise that power? We also have this interesting paradox of, well, how do we identify who the people are? Well, they're the ones who exercise constituent power. But do they not have to exist first before they can exercise the power? So you get into this quite circular confusion. But ideally, it's the people who possess it. But that's not necessarily what happens in practice. And you can have conceptions of constitutional orders where maybe the people's possession of constituent power is quite weak. So you could have monarchical conceptions of constituent power or aristocratic conceptions of constituent power. So prior to the enactment of the Free State Constitution, and when Ireland was part of the UK, if you look at conceptions of constituent power in the UK, and obviously that's potentially going to be influential on, as we've heard from the Attorney General, the individuals in the case of Ryan versus Lennon who are steeped in the British constitutional tradition. Constituent power is almost conspicuous by its absence in the UK. And that's arguably because of an aversion to all things French Revolution that's very clear in British constitutional theory. But you do have some theorists who argue that, constituent power has no function in the UK constitutional order because parliamentary sovereignty essentially does what constituent power does. So Martin Loughlin, for example, argues that it forms no juristic function in the UK. Alexis de Tocqueville described Parliament as at once a constituent and constituted assembly, as once a legislative and constituent assembly. And Joël Coll-Henrios argued that, well, you don't have a need for constituent power where Parliament can create any other norm that it sees fit. When you do see constituent power used in the UK parliamentary discourse, it's normally in relation to the power to create constitutions for the colonies. So essentially, there's no real engagement with the conception of constituent power. At best, there's a notion of what's termed derived constituent power, and Parliament possessing what's known as derived constituent power that we have seen emerge as people try and explain things like the Brexit referendum and the role of the people in the UK, where the argument is that Parliament possesses constituent power, but it derives it from the people. So really, the people are the key possessors of it. The problem with that is that derived constituent power as a theory essentially emerged quite substantially from the United States, where when the respective states were drafting their constitutions and they were afraid of a constituent assembly becoming a runaway assembly. So there was a key emphasis in terms of the people elected to those assemblies that they were delegates, they were not representatives. And as a delegate, they're instructed. They don't have the freedom that a representative would have, which is what Burke had argued so forcefully that Parliament has. So that idea of derived constituent power is quite has been invoked to explain the UK, but I think it's quite problematic. So how does that arise in Ireland? Well, did the subsequent Oireachtas become a runaway assembly? When it was given, when the Constitution was drafted and when it was designed, and it was being subsequently amended, what was the nature of that power being exercised? Has that been theorized sufficiently? And you see this in the judgment, particularly in the State Ryan versus Lennon, of the judges trying to grapple with this, to grapple with the nature of the power. Particularly Chief Justice Kennedy is looking for a reason as to why the third Dáil was somehow more a legitimate possessor of constituent power, although he doesn't use the language constituent power, than the subsequent Oireachtas. And his phrase, he argues that essentially because it was only the Dáil that ratified that constitution. As he describes, it was unfettered by any test, and there was no nominated or unrepresentative element. So essentially, there was no Senate. And he's trying to use that to argue that the third Dáil essentially was more democratically legitimate, a better representative of and an exercise of constituent power than maybe the subsequent parliaments that came after that. The problem with Chief Justice Kennedy's argument is when you read through it, so aside from the natural law arguments there, he is trying to distinguish somewhat between the legislative power that's possessed by the Oireachtas and the power to create a constitution and also the power to amend the constitution. So he's trying to distinguish between the three. But that language of constituent power is never really used. He describes it essentially as like a legislative power. So he describes it as the only act of legislation by the Constituent Assembly was the Free State Constitution. But he tries to elevate it up by describing it as supreme legislative authority. So there's an attempt there to get some attempt of constituent power and distinguishing between the two, but the grammar of constituent power is not actually used. And this is when we're thinking about Paul Gallagher's piece earlier on about how the drafters of the Constitution did really well on the basis of the scarce sources that they have. It's arguably the same as well with judges early in the state. They don't have the access to the literature, to the material that we have. But really, there's no real interrogation in that judgment either of why the third Dáil possessed this constituent power. There is the attempt to separate it from the subsequent Oireachtas, but there's no real attempt to engage with the relation between the Dáil, the third Dáil, and the people. Again, it's that the key there is that representative idea, but it doesn't necessarily give effect sufficiently to the role of the people as possessors of constituent power. In contrast, Justice Fitzgibbon's judgment is very much, you can see, as we heard again from Paul Gallagher, steeped in the parliamentary sovereignty tradition. There's no real engagement with that conception of constituent power. He also tries to read limitations into the legislative power of the Oireachtas, which is somewhat of a break, somewhat of a departure from parliamentary sovereignty, but it's done expressly in a very literal terms in terms of the provisions of the treaty. So they can't amend it in breach of the treaty. But I'm going to finish up now. But in terms of the other areas, there's almost a free carte blanche. And you do see there the elements of parliamentary sovereignty flowing through. So why does this matter? Well, I think it matters because that ambivalence towards constituent power arguably is still in effect and still in play today. We've not necessarily unpacked the key distinction between constituent power and the amendment power or the legislative power. And there's a problem with that in that if we conceptualize constituent power as solely as an exercise of the amendment power, then we view all constituent acts, all forms of constitutional reform as being driven through the amendment power. And it means if we need areas where we need kind of, innovative constitutional thinking, like I'm thinking about Irish reunification, the debate so far has not really engaged with this conception of constituent power. What would that look like? How would that be exercised? How can we ensure that the constituent power is exercised by the people? Currently, it's being framed very much in terms of representatives and a referendum. Work of Owen Daly suggests that we can't just collapse constituent power into an amendment power or into just simply a referendum, given the fact that the referendum question put to the people is very much shaped and constrained by constituted powers. So there might be an issue there in terms of the creative potential of constitutional imagination not necessarily being unpacked sufficiently. And I'm going to leave it there because I went over time. Cheers.
Well, thank you very much, Alan. And I have a difficult job because it's such a rich panel with lots of different strands of thought that I'm hoping we'll get a chance to have questions. I turn now to Dr. Tom Hickey from DCU, who's going to talk about the amazing case of State Brian and Lennon. It was the first case I ever read in UCD and was really mind-blowing. Look forward to your 15-minute presentation.
Thank you very much, Aileen. So great papers before. Thanks to Donal and Laura. So it was actually at another conference organised by Laura in the University of Limerick about 5 years ago that the now Chief Justice, Donal O'Donnell, gave a keynote paper called "The Sleep of Reason." It was published afterwards in the Dublin University Law Journal. I recommend it very highly, right? But in "The Sleep of Reason," Judge O'Donnell is sceptical about the Kennedy dissent in State Ryan and Lennon, right? He's inclined to suggest that he's not so persuaded by what he calls the very florid form of natural law theory and the essential bluntness of Judge Kennedy's analysis, right? So Justice O'Donnell is not impressed. In that paper, The Sleep of Reason, I think Judge O'Donnell is more focused or concerned about how the Kennedy dissent is received, right, over the years, the later years, the decades ahead, right? So he loses, right, in State Ryan and Lennon, as we know, but he goes on, as Judge O'Donnell says, to win the hearts and minds of Irish public lawyers, right? That this great dissent, if you like, captures the imagination, right? It excites the drafters of the 1937 Constitution. It captures the minds of the important teachers in influential law schools or in an influential law school in the 40s and 50s. And then it kind of plays out like in the jurisprudence of the superior courts in the 60s and 70s, right? This is Judge O'Donnell's suggestion. We see bits of it like in the papal encyclical, right, in Gladys Ryan, and particularly, I think, spectacularly, right, in the Judge Brian Walsh judgment in Mary McGee. And of course, that is, along with the Kennedy dissent, was an extraordinary celebrated judgment. And Judge O'Donnell, right, is not so sure, right? Essentially, he says, that this kind of betrays a weakness in the mind of Irish public lawyers, like so for kind of this image of the judge as part lawyer, part poet, right, part philosopher, right? And as O'Donnell says, in The Sleep of Reason, you get this. I don't think he's not pinning it all on Kennedy, right? But certainly it begins with him, this implicit endorsement of the view that a lawyerly approach to the Constitution can be discarded in favor of a more mystical, philosophical approach, in which the judge can delve into the natural law to ascertain desirable developments in society, right? And it's from that then that we get this sleep of reason, which is a very clever, right? Use of Goya's image, right? It's in the sleep of reason that monsters come. The idea that the judges in these cases have deviated from the traditional legal method, the judicial method, right, where every little bit of the judgment has to be reasoned out, right? So Judge O'Donnell, as he often does, quotes Herbert Wechsler, right, the main constituent of the judicial process. It must be genuinely principled, resting with respect to every step that is involved in reaching judgment on analysis and reasons quite transcending the immediate result that is achieved, right? So the suggestion is that insofar as judges deviate from that method, that over time the monsters come, right, that the standing, the status of the judge and the court diminishes over time, and the capacity of the Constitution to function as a kind of legitimacy pact, right, declines, right. So it was in this context that I look back on the Kennedy judgment this past few days. And if I may, you may indulge me for a minute, like it struck me this week, like it's actually 20 years since I first, you said, Aileen, you encountered it, as an undergraduate law student, right? Jared Quinn in NUI Galway, we first read Kennedy's judgment. I think I've read it, I would say, this week might have been the 4th time that I read it carefully, and I can see that Alan Greene obviously read it very carefully recently as well. And I have had this kind of sense over the last, I think subconsciously, the last couple of years, like that I have tended to over-celebrate, right, the Kennedy dissent, but also I think to actually underappreciate, I would say maybe, quibbling with Alan a little bit, to underappreciate its lawyerly sophistication, right? We celebrate it because, of course, we appreciate as lawyers what was at stake, right? The constitutional edifice is at stake. We have this strong sense Kennedy was right. Kennedy was right. He would have got the right answer, if you like. And we're always drawn to, this is kind of Judge O'Donnell, we're always drawn to the judgment that gets the right answer. Mary McGee, Brian Walsh, etc. Right? And also there is that kind of fierce, visceral kind of defense of the rule of law in this great judgment, right? But it's almost like we can relate to that kind of that anger that courses through the whole judgment. But as I say, as I read it this week, that anger, right, or that kind of, that disgust almost, it doesn't actually course through the whole judgment. So I was rereading it, and if there's somebody in charge of those slides, if you could switch it on to the second slide for me, perhaps there isn't. So there's 4 chunks, right, 4 quarters, right, in the judgment. And to my mind, the piece that we all learn about as undergraduate students and all write about when we write is in the first chunk, right, and it's the most visceral chunk, right. It's when he's setting out, right, the substance of Article 2A. Right, and you get all those lines that some of us will remember, this is an abomination, right, this is a retrospective punishment, right, the favoured instrument of tyranny, the more one dwells on this paragraph, the more staggered one becomes, and so on, the antithesis of the rule of law. All those lines come early on, and that's, of course, we're drawn like flies to a light, to that feature, that aspect. But then, it's like as if he kind of regains his composure after the first quarter and begins to think less like a singer-songwriter or a poet, if you like, and more like a lawyer, right? So he kind of clarifies what the question is, the legal question to be decided in this case. He says it's the question as to whether the Oireachtas validly, right, and effectively brought through these amendments. And immediately then, this is why Alan's paper was so interesting, immediately then he switches to consider what he sees as critical features of the historical context of the emergence of, or the enactment of this Free State Constitution, and features of the institutional relationships at play, which he sees as critical to the determination of that legal question, right? So it's now a legal judgment, very much, if you like, and what is he's interested here in he gets this image, he makes this point, he says, I must emphasize, he says, the first thing I should emphasize is that the Constitution was enacted by the Third Dáil sitting as a constituent assembly, right? This is Alan's, but not by the Oireachtas, which in fact it created. Right, so you're getting this image, and I think, Alan, it comes a lot in the good parts of the judgment. You get this image of the Oireachtas here, right, which only comes into existence on 6th of December on foot of the coming into operation of the Constitution. The Oireachtas relies for its existence on the Constitution. And the Constitution relies for its existence on the Third Dáil, the Constituent Assembly. So that image really does course through important parts of the judgment. And here we're getting that the Third Dáil is a single chamber parliament, and of course there's no oath. Membership is not conditioned on an oath, right? And ultimately I think he decides the case in the end on that basis. He also makes the point that if if the Constituent Assembly hadn't conferred on the Oireachtas a power to amend there wouldn't have been a power to amend the Constitution. That another Constituent Assembly would have had to be convoked for that purpose. But he says it's true, of course, in Article 50, the Constituent Assembly does confer that power on the Oireachtas, but it limits it, right? And he says it's limited. That power is limited and circumscribed by a number of restrictions in respect of the manner and conditions of its exercise and in respect of the substance of the amendments permitted. In other words, what he's saying is he's really thinking like a lawyer now. He's going through the nuts and bolts, right, and looking at it in the context, right, and he's saying there are process-oriented restraints and substance-oriented restraints. And that feeds then into the two, like the third chunk and the fourth chunk, right? And it's in the third chunk that we get the substantive restraints. And that's when God creeps back in again a little bit, right? We have that other line, you know, all lawful authority comes from God and so on. Can we justify? No, we can't. Like the arbitrary use of the death penalty, would God approve? No, he wouldn't, right? So that reappears. And of course, we as law students are drawn to that. So what I'm saying is we're drawn to 1 and 3, when the really interesting parts of the judgment are, to my mind, 2 and 4, because it's in part 4 then that he says, well, what are the process-oriented constraints? And then he goes, okay, let's look at the language of Article 50. Look at the text, right? It's pretty wordy. It's not that terribly elegant, I don't think, right? But it's got these certain clauses and so on. And what does it say? It says, essentially, you step back from it, it says there's 2 powers of amendment, right? And there's a practical difference between the two of them, procedurally speaking, right? One of them operates for the first 8-year period until 6th of December 1930, and then the other kicks in and operates indefinitely thereafter. And he says the difference between the two is after the expiration of the 8-year period, the Oireachtas is forbidden. It's forbidden to, right, amend the Constitution without recourse to the people, right? Whereas in the 8-year period, a referendum or recourse to the people is not required unless it's demanded by Article 47, right? So he says the key point is that the referendum could always, during the preliminary period, even during that 8-year period, could always be demanded and insisted upon, so that, as he says, the check and control of the people could at any time be exerted, right? So he then says that a moment's consideration will demonstrate that this clause was enacted, this Article 50 was enacted in clear realization of the relative positions of the Constituent Assembly and the Oireachtas. And that's why I find Alan's paper so interesting, right? So the Constituent Assembly saw themselves as, right, because there was no condition on membership, of test or oath or what, saw themselves as representative of all the people and knew full well what was going to happen down the tracks, that this Oireachtas was going to have, or may have at least, a representation deficit. And says Hugh Kennedy, that is why we go to these lengths, or the drafters go to these lengths, to come up with these sophisticated institutional mechanisms to protect the sovereignty of the people. Article 47, detailed. Article 48, detailed. Article 50, clarifying in it that Article 47 kicks into play for fear that it wasn't already clear enough. In other words, bending over backwards to make sure that the sovereignty of the people would be protected. And it's in this kind of more sophisticated way, of course, the referendum is not conditioned on an oath or whatever, you know. So, in other words, they are, you know, it's rooted in the principle of popular sovereignty. So in other words, what Kennedy is saying is that, right, it is very clear on the evidence of the text of the Constitution itself. So it's not poetry, it's not God's law, right? It's the mundane nuts and bolts of the judicial process, right? That the Assembly intended and tried to preserve intact the overriding authority of the people. So what's my point? I mean, I was thinking to myself this morning, like, do I have a point? I'm not terribly sure if I have it worked out yet, but like, one is that I guess, you know, like, it's a big judgment, right? We always talk about it, we still teach it, like, and I think that possibly will continue, and I guess we ought to understand it, you know, and I do think we are drawn to 1 and 3, right? Although I was very interested in Alan's paper that he isn't, evidently, right? So we must understand it. But also, I think more broadly, right, I would say that Kennedy goes for the haymakers, like in 1 and 3. And it's interesting that Fitzgibbon, particularly, maybe Murnaghan as well, like that's what they use, right, to win the day in the Supreme Court. They ignore the intricate, the more hard work stuff. In other words, right, that judges ought to, right, appreciate and understand that, like, how to decide a case is in that mundane way, if you like, and that may have implications over time for the standing and status of courts and for their capacity to exercise or to carry out that function as a kind of a legitimacy pact for the people. So look, I'll be interested in the conversation. Thanks, guys.
Wonderful. Thank you, Tom. I'm sure there'll be lots of questions on that. And it's also a reminder that the legacy of the 1922 Constitution is not just in the formal text, but also in the jurisprudence, the judicial thinking, which certainly had a lot of resonance even, you know, perhaps up to the present day. So now we have our final speaker, Dr. Jennifer Kavanagh, no relation, at least as far as we know, with a great title, What Became of Direct Democracy?
We have actually tried to check, and we are definitely not related. I just said I'd clarify that at the very start. So what I'm going to talk about in this presentation is specifically Articles 47 and 48. The title of Fire Lit comes from W.B. Yeats about education, that education isn't just about filling a bucket, it's about lighting a fire. So I'm kind of taking that approach to direct democracy and how it worked in Ireland. So at its basic first principles, direct democracy is any ability for the citizens to be more engaged in what is actually happening in their jurisdiction. The classic example would be Switzerland, where you have a change.org petition and you can have your constitution referendum on your Constitution Day. In fact, it was actually, that provision was actually looked at by the very early Sinn Féin and what kind of way they wanted a new Ireland to run, and not just on direct democracy, but almost a canton-style situation as well. So the provisions of Article 47 are actually quite like what's there in Article 27 at the moment, where members of the Oireachtas, if they have a particular bee in their bonnet with legislation that is going through, they can have a petition, send it to the President, and possibly trigger an ordinary referendum. It's never actually happened in the history of the country, but yet, it hasn't happened yet. But what Article 47 did was it allowed for the citizens to also have a mechanism whereby if there was specific legislation coming in that they didn't like, that there was an ability to have an ordinary referendum on that. Article 48 then, so if you had 75,000 signatures, you could have a constitutional referendum. For legislation, it was what is it there? This is like an eye test here. 55,000. So they were removed in 1927. William has already taught in depth about all the different provisions that were changed there without reference to the people. So the basic idea behind getting rid of these articles was De Valera, during the general election, was saying, we'll get rid of the oath, we'll get rid of this and all the different areas. Absolute consternation at this, because it would be affecting the foundations of the treaty provisions in the Constitution. De Valera still got away with it at the end because the Oireachtas themselves had actually opened Pandora's box in their ability to change the Constitution. During the debates themselves, reading the debates, I wish somebody would just make it into a Netflix series, because they were exceptionally dramatic, with De Valera shouting about sharp practice. There was private members' bills coming in to try and get an actual referendum on the very provisions they were trying to get rid of. In the Seanad, there was, even if you just look up the Oireachtas database on the debates, there was stuff even coming up about Cork cooperation. And I think for the Dublin people, once they saw Cork trying to get involved, it was like, no, it has to go. That's the end of that. So the time periods that I'm going to look at on citizen engagement in constitutional change is from that time period of the first constitution, the 1922 constitution, the time period between 1937 and 2011, And the time period of 2000 to 11 until now is best summed up by Father Ted. Is there anything to be said for another mass, but change it to a referendum? Because we just love referendums now, constantly having referendums. The only thing that put a stop to their gallop was COVID. And I think people were delighted with that. We're just not going to have any referendums because of this at the moment. So one of the things that they did learn from the 1922 Constitution was to ensure that peace on referendums and allowing for the Dáil to change things, or allowing for the Oireachtas to change things, it was literally, we'll make sure that it's written in a way that from the 1922, it was the whole idea of you can change anything in this Constitution, anything, even the Constitution. Yes, go for it. So when we brought in the 1937 Constitution, it was, you can change anything in this Constitution for a period of 5 years, bar this article, because we saw the shenanigans you got up to the last time, and we're not going to leave you away with it this time. So it was a slow start. So you had the 2 referendums on trying to move to a first past the post system. You had, which my students are always fascinated to learn, a referendum getting rid of the special position of the Catholic Church, because the generation that we generally teach looks back at that time and is wondering why we weren't all just going around chanting Latin Mass at each other, because Ireland was so, to their eyes, so conservative Catholic. The referendum to remove the special position, membership of the European Union, those sort of things. But then things sped up then once we had the idea of the new politics. Things started speeding up from around the late 1980s onwards. So we've had a profound amount of social change reflected in those referendums. So firstly, putting in the 8th Amendment, then getting rid of the 8th Amendment, removing blasphemy, divorce. Of course, the first one failed. The second one then just had more provisions in it. Removing the death penalty, so on and so forth. I would be here all day if I went through every single one of them. So on a very basic statistical analysis, if anyone actually does know statistics here, they will probably go through me for a shortcut. But if we look at just 4 different areas of constitutional change, so international would be our international commitments to remove the death penalty, International Criminal Court, 100% success rate. EU, so you know, with the Nice 1, Nice 2, Lisbon 1, Lisbon 2, not as good a success rate. Civil society driven would be the second most successful, and they would be the ones that I would class as the 8th Amendment, removing the 8th Amendment, divorce, all those sort of things. And the interesting one is what I would class as technical or political, like the first past the post system, Enda Kenny's idea of removing the Seanad, which apparently he only announced at a dinner, and the senators were nearly coughing up their starters going, he's going to make us redundant and he's made us pay all this money for a table at a dinner. And political ones as well, such as the Oireachtas inquiries. It can nearly be summed up that the Irish electorate voting in referendums gets very suspicious when we see a referendum that may just make life too easy for politicians. So therefore, no, we don't trust it, get rid of it, not happening. So the reason why I look at 2011 is that was when the Fine Gael Labour government came into power, and one of their biggest ideas on that 5-point plan, nobody can remember any of those points anymore. But one of them was a new politics. So it was the whole aftermath of the crash, making sure that there was more of a voice of the citizens in there. There was even parties coming up with different names and different play on the words of direct democracy in there as well. So a lot of things changed. So for example, the election of the Count Corla, all those different things. But Labour was moving on the idea of we need a new constitution. Obviously, with the programme for government, Fine Gael had their own ideas again, and it was let's create a constitutional convention, which was based off that political science experiment of we the citizens. You could also argue, was it slightly populist, giving people this sense that they had a sort of control over the constitution, when in reality, everything had to be moved through the Oireachtas. And maybe you could even say that trying to remove the Seanad in itself was maybe a populist idea as well. So there was more pre-legislative scrutiny came in. We brought in the petition system, when you look at the Oireachtas, so there is now that specific committee that is there in the Oireachtas with people having ideas or issues that are very important that they feel maybe need legislation or stronger consideration of. So then we had the formal establishment of the Constitutional Convention, which then later morphed into the Citizens' Assembly because the Constitutional Convention had a lot more Oireachtas members and Northern Irish involved in it. The Citizens' Assembly, not so much. So if you look at the referendums that came from both of those bodies, so for example, Constitutional Convention was looking at marriage equality, it went through. There was the issue of bringing down the age of eligibility for running for the president. Nobody wants to talk about that anymore because it was such a disaster. And then remember that the actual idea of repealing the Eighth Amendment itself actually came from the Citizens' Assembly. So they do tend to do better, the referendums that come from this. But remember, all of this work plan is actually set out by the Oireachtas itself. So I've raced through this because I know you all want to get lunch, and it's always the worst thing being the last speaker before lunch. So the direct democracy provisions that were there in the 1922 Constitution, they were removed. But I would argue that they came back because we had that sense of connection with a constitution, with an ability to change it. And that then was kind of pushed through by those different bodies, by that political and civil society action looking for changes in it. And that citizen engagement is really important because we can see that they are the second most successful class of referendum and possibly one of the largest groups of referendums that does actually happen. So one thing that could be done to make it even more direct is maybe allow for that petition system to consider the possibility of referendums through that provision of creating those deliberative democracy bodies like the Citizens' Assembly and Constitutional Convention, because it would allow for those issues that people do feel very strongly about to actually make it towards a more formal discussion. So a good example of that would be the Dying with Dignity legislation that was there in the Dáil, that a lot of people, the opinion polling would show that there's a very strong want for that to be there and considered, if nothing else. And we can always see as well that with the Eighth Amendment stuff that the general population are at least 5 years ahead of where the Oireachtas members are thinking. So it's good that we have those bodies, but maybe it's time that we also consider making that connection a bit stronger without putting in the automatic provisions that were there in Articles 47 and 48, because as we know, change.org is there, that we could be having referendums over everything every 5 minutes. We like elections in Ireland, but probably not that much. Thank you.
So thank you so much for a rich set of presentations. I can see that we've got some questions already. I just have one question. We have a roving mic, by the way, if you put your hand up, and I'll get to you in just one second. But just a general question I have, if one member of the panel could answer. We talk about the new politics and, citizens' assemblies and constitutional conventions. But what's remarkable sitting in this hotel today is that 100 years ago, these, what now seem like modern, innovative procedures, where constitutional scholars from all over the world are coming to Ireland to work out how these citizens' assemblies and engaged participatory forms of democracy work so well. But they were there in 1922, 100 years ago. So my question is historical, really. Were the drafters who were in this hotel 100 years ago, were they aware that they were doing something, as Laura said, innovative rather than imitative? Were they aware of how radical it was at the time to give people such a strong role in amending the foundational legal document? Anybody want to take on that?
Well, I suppose I was the one talking about it, so I might as well go first on that. I think they were, and that comes out very strongly if you read any of Bill Cassan's works, because they almost wanted to go even further, but were almost constrained then by, obviously, the United Kingdom going, well, look, we're giving you your independence. We kind of need to see something that we're going to recognise as well. So I think they did.
Right. Okay. Thanks. So we've had a wonderful panel. I'm getting the sign to wrap it up, which I'm very reluctant to do so given the calibre of the speakers and the wonderful discussion. But I'd invite you all to thank the panel for a great set of presentations.
Thank you.